Welcome to the debate. Before we jump in today, just a quick reminder to please like, subscribe, follow, and turn on the notification bell so you never miss a show.
Always important.
Yeah, definitely. Also, just a brief legal update for everyone following along. The Martin Stevens versus OpenAI matter is, well, it's still not a lawsuit. We are currently in a deliberate, voluntary quiet period at Martin Stevens' request, just to idle new public information.
Right.
So we hope they are working toward a settlement in the background, but at the time of this recording, it's unknown if any progress has been made, and we really aren't trying to give the impression that settlement or discussions are actively underway. Finally, the dead man switch has not been activated, meaning Martin Stevens remains safe, physically and legally.
Good to hear. It's, good to have that cleared up.
Absolutely. So, getting to today's topic. When a lawyer cites a case, that citation is supposed to be, well, poured concrete. But what happens when the concrete is mixed by an AI, and the legal precedent it cites just doesn't actually exist? Today we're examining ethical AI oversight and legal veracity in modern courts. We are looking specifically at this rising trend of lawyers being sanctioned for submitting hallucinated case law.
Yeah. Getting back to that poured concrete analogy, the introduction of generative AI into the drafting process is, it's creating what I would call a structural integrity crisis in the courts right now. We're looking at a landscape of legal veracity that is shifting right under our feet.
Right. And that brings us to our central disagreement today. Does the introduction of generative AI into the legal field require a fundamental overhaul of our systemic safeguards? I argue that our existing procedural frameworks are entirely sufficient because AI errors are, at the end of the day, ultimately just standard failures of human diligence.
And I argue that the uniquely deceptive, frankly probabilistic nature of AI hallucinations requires a total paradigm shift. We need new systemic technological safeguards.
Well, let's look at the procedural bedrock we already have, right? Specifically, Federal Rule of Civil Procedure 1 and, its state equivalents. Rule 11 explicitly requires attorneys to certify through their signature that they have conducted a reasonable inquiry into the facts and the law.
Right, but
So if you submit a fake case, you violated Rule 11. It's that simple. We don't need a new, AI rule. The Fifth Circuit Court of Appeals actually explicitly declined to adopt one recently. They noted that existing rules and the court's inherent power to sanction are, well, perfectly sufficient to punish the misrepresentation of facts. AI is just an assistive tool. Relying blindly on it is no different than, say, an attorney failing to supervise a junior associate or a law clerk.
okay, while Rule 11 absolutely exists, the scale and the nature of generative AI, it fundamentally breaks those traditional human oversight models. We have to look at how large language models actually work beneath the hood. They do not reason.
Right. They operate probabilistically.
Exactly. They are essentially just guessing the next most likely word in a sequence based on their training data. And because of that mechanical reality, they present fictions with this incredible veneer of absolute coherence and confidence. There's some fascinating research out of Princeton University looking at exactly this. It shows that an AI's tendency to try and satisfy user expectations actively compromises its factual accuracy.
Meaning it prioritizes sounding helpful over being truthful?
Spot on. Yeah, it's trained via reinforcement learning from human feedback to be as, quote-unquote, helpful as possible. So if a lawyer asks an AI for case law supporting a highly specific, maybe even a losing argument, the AI's primary directive is to give the user exactly what they asked for, even if it has to just invent a judge and a ruling out of thin air to do it. You really can't rely on a trust but verify model when the tool itself is actively designed to bypass your natural skepticism.
I see why you think that, but let me give you a different perspective on this. That is a compelling mechanism, sure, but look at how the system is actually responding to the threat right now. It is working exactly as intended by punishing negligent lawyers post hoc. Failing to verify AI output. And Magistrate Judge Thomas Hickson recently fined attorney Jessica Barsotti $1,000 for fake citations. The system is actively catching and penalizing these people.
Yeah, I'm sorry, but I just don't buy that. Let me tell you why. Those are just the ones that got caught.
Well, look, when the IBM Selectric typewriter was introduced, right, it vastly sped up document creation. That made it easier to reproduce errors at scale. AI is essentially just a faster typewriter in that regard. The technology changes, but the non-delegable duty to verify your authorities, that remains exactly the same.
Comparing a large language model to an IBM typewriter completely misunderstands the threat, honestly. A typewriter doesn't actively invent a judge and construct a perfectly reasoned, completely fake holding just to please you.
Well, sure, but
And that Nolan case you just mentioned, that actually proves my point. Yes, the attorney who used ChatGPT and Claude to fabricate 21 case quotes was sanctioned. But do you know what else happened in that case?
opposing counsel missed it.
They completely missed it. They filed their respondent's brief without ever noticing the hallucinations. And the threat goes even higher than that. In the Shahid versus Issam case, an actual judge incorporated AI hallucinated citations into a judicial order. If opposing counsel and judges are being tricked by this, this camouflage of competence, this goes far beyond mere attorney laziness. It is systemic pollution of the docket.
Okay, I have to admit, the fact that opposing counsel in Noland didn't catch the fabricated cases, that does expose a real vulnerability in our standard expectation of human diligence. I'll grant you that the illusion of competence is very strong, but your solution is to mandate what exactly? New technological guardrails?
Yes, absolutely. Damien Charlatan, he's a data scientist. He maintains a database tracking AI hallucinations in the legal field, and he has already logged over 800 cases worldwide. Mere deterrence is simply failing. The Thomson Reuters report specifically recommends that courts mandate professional-grade vertical AI solutions.
Wait, let's pause there for a second. When you say vertical AI solutions, you mean?
I mean AI that is strictly fenced into closed, verified legal databases. Unlike horizontal models like your standard consumer chatbots that just scrape the entire, completely unfiltered internet. We need these vertical systems with integrated citation verification checkpoints baked directly into the workflow.
Fencing AI into closed proprietary legal databases sounds incredibly appealing, I'll give you that. Until you look at the reality of the access to justice gap in this country.
Right, it's a huge issue.
It is. How can courts practically mandate these expensive professional-grade tools without completely locking out the most vulnerable populations? Out of those 800-plus hallucination cases you just cited, over half of them, about 430, I think, involve pro se litigants, people representing themselves who only have access to free, consumer-grade chatbots.
It's a profound dilemma. I agree with you there.
Yeah, and as U.S. Magistrate Judge Maritza Braswell noted recently, holding AI to impossible standards hurts thousands of unrepresented people who desperately need legal assistance. The solution just isn't to lock AI behind expensive professional paywalls. It is to enforce the existing duty of candor for everyone, while allowing these tools to actually help close the justice gap.
But compassion for unrepresented individuals simply cannot come at the expense of court integrity. Those consumer tools are optimized for conversational fluidity, not for legal precision. Look at the Thomas case. A pro se litigant was actually sanctioned for acting in bad faith by delaying and disrupting litigation with hallucinated authorities.
Right, which shows the sanctions work.
But we cannot run a functional judicial system if the dockets are flooded with fabricated case law, regardless of the litigant's financial status. The probabilistic illusion of generative AI demands a do not trust until verified paradigm with systemic built-in verification checkpoints.
Well, I think we definitely find convergence on the fact that the efficiency gains AI offers are undeniable. And I know neither of us is suggesting we just abandon the technology entirely.
Oh, definitely not.
And we also agree wholeheartedly that ultimate accountability has to rest with the human in the loop.
Absolutely. The human is the final backstop. But because these tools predict words rather than retrieve actual facts, their errors are just incredibly difficult to spot. Asking human beings to constantly outsmart an algorithm that is designed specifically to satisfy them, it's a losing game without integrated verification tools.
And from my vantage point, an AI must remain an assistant, not an arbiter. If you sign a pleading, you own the words. The existing rules of professional conduct forcefully uphold that standard, and rigorous enforcement is the key. It will certainly be a fascinating tension to watch as the technology evolves and the courts have to adapt.
It will indeed.
Well, we will leave it to you, the listener, to form your own conclusion on whether new procedural rules are needed or if our current ethical frameworks will hold the line. Please remember to like, subscribe, and share the show. We started today by talking about the poured concrete foundation of our legal system. Whether that concrete is mixed by a human associate or a generative algorithm, the question remains: when you step out onto it, will it hold your weight?